We'll talk a little bit about challenges to resolution from a prosecutorial perspective, and then also about different means of accountability as well as post-adjudication options for victims and offenders. Okay, so just to touch, and I know that a lot of you are working in these areas, and so I think it is critical because they're all partners in this field of domestic violence. It's critical to talk about them. But essentially, what we often see happen once physical violence has occurred, an assault has occurred, whether that's domestic violence or the child abuse side, law enforcement will oftentimes, not always, it's going to take somebody reporting and calling law enforcement for assistance. Law enforcement will intervene and come out to a scene, do an investigation, and there are actually some services and some resources available to victims and families at those early stages. And this is really right before the criminal justice part is actually starting. So from the beginning, there are a number of options available to our victims. We see over the years, we've seen actually a lot of changes where law enforcement previously used to have some positions and some roles, particularly the San Antonio Police Department used to have some roles where they had some victim advocates, victim services type professionals that were helping navigate through this. Now we see those positions really, that work really turn over to Metro Health. So of course, and some of you are probably from Metro Health, but Metro Health is a critical partner in providing services to victims at those very early stages. I also want to mention Child Safe and our local child advocacy center for people from other jurisdictions. There might be a different child advocacy center or one close by. Those child advocacy centers are critical as well in providing services to families. Anytime that law enforcement has deemed that a child has been witnessed or directly been affected by or part of the domestic violence, or even the child, if it's direct violence and it's child abuse, we really want to encourage law enforcement to be reaching out to Child Safe to assure that we are having Child Safe, our child-friendly, super trained professionals talk to and meet with kids to determine what resources are needed, to determine what is the best way to go about the healing process throughout this whole system from beginning to end. And so Child Safe is able to do a whole lot of those things, from counseling. Forensic interviews are one avenue that are extremely critical, not only to the prosecution. When we are ultimately proceeding on a case, those forensic interviews are a good way to document and discuss the level and the extent of abuse in a case. And those forensic interviews are also extremely beneficial to, for example, CPS, who might be able to better ascertain what types of services are appropriate for the families and the kiddos in our cases. We, of course, have, and many of you are probably part of, our local community-based organizations, organizations that are not affiliated with the criminal justice system, and we have a number of them, are able many times to assist in meeting the needs of victims and children, and providing those types of counseling. Sometimes it's legal aid, sometimes it's crisis intervention or safety planning, but all of those wonderful services that our community-based advocates provide are critical, particularly in the field of domestic violence. And when we get to kind of the struggles of prosecution or the challenges towards prosecution, we'll talk about that a little bit more. Sorry, somebody's not muted.
Office.
Okay.
He is not Mr. Valdez.
Hi, can I proceed?
Yes, go ahead. I've muted everyone. But now you're muted.
Okay, how about now, Darren?
Perfect, thank you.
Okay, no problem. Sorry about that. So So our community-based advocates are often, I said we will talk a little bit later about why the community-based advocates and our victim service professionals at those early stages of a criminal case are extremely important. And we'll get to that in just a little bit. One of the first avenues that we have to help assure victim safety in this criminal justice system are what we call our magistrate's orders for emergency protection. There are different people in different areas call them different things. We typically, from the prosecution side, will refer to them as EPOs. It's just the acronym that we typically use. I'm not sure exactly why, but that's what we'll refer to them as. So for an EPO to become available, there has to be an arrest. This is a protective order, a temporary type of protective order that is requested at the time of arrest when there's been an offense involving family violence, sexual assault, human trafficking, stalking, things like that. What can happen and what should happen is law enforcement should be notifying victims, survivors who are going through this process that those emergency protective orders are available and should be applied for and requested when appropriate. A victim can request them, law enforcement can request them, the prosecutor can request them, and court can actually issue them sua sponte as well. They're not mandatory unless there is evidence of serious bodily injury that has occurred or a deadly weapon has been used. These are they're temporary protective orders because they last only for a finite period of time. So once they are signed, once they are served upon an offender, and usually that's at the time of magistration, then the information is entered into TCIC so that law enforcement has access to that information and knows of their existence. The victim in these types of protective orders is most often not present and does not need to be there. No hearing is required, and typically we see them last anywhere from 30 to 60 days on our family violence cases, and longer when there is, again, a serious bodily injury or a deadly weapon. It's important to know, and that's why your regular civil protective orders come into play. Since these are temporary, we are not able to get an extension, so it's incredibly important for law enforcement, as well as those of you providing services to victims, to be able to say, this is just, to bridge that gap during this cooling down period and to make sure that we are providing an opportunity for victims to have that distance from their offenders. But it is critical that they follow through, if desired, on a final civil protective order. So concurrently and at the same time that a emergency protective order is signed, one of the available options to all of our judges who are handling the arrests of offenders are the options for them to enter into and sign off on any kind of bond conditions that they may deem appropriate in this particular case. So bond conditions are going to be issued after an arrest. They are going to usually be required to be followed throughout the pendency of the case, unless and until there's an amendment or a change in those conditions. Usually how we see those start is the starting point is usually with an amount, a bond amount, that a judge has to take a number of factors into consideration, and we'll talk about those. But to set a bond amount in most of our criminal cases, a defendant is entitled to a bond. The amount can vary, and that can depend on a number of factors, but it is important to remember that we can't utilize bond amounts simply to keep someone in jail. They are there to assure appearance in court and deter additional violence, but we cannot use them just to simply hold someone in jail during the pendency of their case. One of the most common additional bond conditions that we see and we utilize on our cases are no contact order, or what we would refer to as a no harmful contact order. A no contact order is just that. It operates in essence like a protective order. If there's a violation, that is a criminal offense. It means just that what it says, there's to be no contact, direct or indirect, between an offender and a victim. A no harmful contact order typically is something that we might ask for when we have an offender and a victim that are that have children together, that have to engage in kid exchange or sometimes going to continue in their relationship, but we want to still try to prevent any future violence where we can. On cases where we have significant concerns about the safety of a victim and the danger that they might be in, we might request, or a judge might order on their own, GPS monitoring or house arrest, so that we can keep a victim notified. And what essentially will happen is a offender will be prevented from, there'll be different boundaries that are set, and that might be preventing the offender from leaving and going to their residence of the victim or their work. And so when there is a violation on a GPS condition, that is something where we can have pretrial services can notify victims that there has been a violation, and we can contact them as well. We've done it before from our office to notify a victim that something like that has happened, and help provide assistance to make sure that they are in a safe place or able to get to a safe place if there are concerns that the offender is going to engage in additional violence. Pretrial services almost operates like a form of probation. So this is all pre-adjudication. All of these bond conditions and bond amounts and the EPO, all of this is pre-adjudication. This is from arrest to the point where we are going through the process and the case is pending, and it's maybe going to go to a grand jury for indictment, or it's going to be filed in a misdemeanor county court. But these bond conditions are very similar to probation conditions, and pretrial services as a supervising entity over people that are on bond is very similar to that of somebody that would be on probation. We have quite a number of bond conditions. One of our very common ones that we utilize also is requesting no possession of firearms, so that if an offender has firearms, or a firearm is utilized in the offense, we can ask a judge, or the judge on their own can order that there's to be no possession of firearms while this offender is on bond. There's a number of other conditions available, these drug evaluation, mental health evaluation, and then any recommendations that come from those. These are critical in really trying to focus on the needs of the offender, right? And many times that I talk about this, you heard people kind of asking me, they're like, Meli, well, why are we concerned about an offender? And we are concerned about an offender because we do want to try and determine what is it that is causing this violence and causing this behavior. What are those root issues, and try to see where we can assist, see where we can address those issues so that this violence does not continue to occur. Sometimes that is drug related. Sometimes there are mental health issues that are involved and some care is needed. Sometimes it might involve behavioral classes like parenting classes or your batterer intervention program, things like that. Employment is also one that we oftentimes will recommend, and that's just because there are some statistics out there that indicate that employment can be a huge factor in reducing recidivism. And so I don't have that site, but I can find it. I should have put it on here. So when setting bond conditions, or say, for example, an offender is on bond and subject to these conditions, these are some of the factors that a court or prosecutor when determining what to recommend, a court when determining what to order, they will consider some of these factors. The code, the statutes very clearly indicate that any bond condition that will help and takes concern over the future safety of the victim or community, it's fair game. Essentially, the purpose of bond conditions is to try and prevent future violence and to assure that our victims are safe, as well as assure that our offenders are going to participate and continue to follow directions and orders and come through the criminal justice process. These are some of the factors that if there is a violation of a bond condition, and I as a prosecutor need to determine whether or not I want to file a motion to increase the bond, I can go to the court and petition to the court and say, essentially, hey, Your Honor, we have a situation, of course, through a motion and through a hearing, we have a situation where we want to ask for an increase in the bond, or maybe we want to amend the bond conditions to assure that they are appropriate. And if there is a violation, we might ask for that bond to be increased or revoked. And these are some of the factors that we might consider when we're making those determinations. I did have a bit on here. Okay, well, this is bond violations. Let me go back and then so bond violations, very similar. It's so very similar to, for those that are not familiar with the criminal justice system or are helping victims who have cases where they're going through the criminal justice system. Some of this I know it might be basic to some practicing attorneys if we have any of those, but I do think that this is important information for those of you that are assisting victims. When there is a bond violation, that in and of itself can be a new criminal charge. And I already mentioned that we have the opportunity to ask or to petition to the court to increase bonds, revoke or deny bonds under certain circumstances, or change those bond conditions. Civil protective orders. So I did have a bit more information on civil protective orders here, but I was concerned about time. And then I was listening to some of the other wonderful presenters, and I thought that civil protective orders were pretty covered. But for those not very familiar with civil protective orders, we have a number, any private attorney. We also have public agencies that are able to assist victims with those applications to apply for the protective order and go through that process of obtaining one. The takeaway, I would say, at least whenever we talk to a number of different service providers, is just to remind our victims, particularly those that my office, the DA's office here, is associated. The Family Justice Center is part of our office, and they will apply. We have advocates and attorneys there that will apply for protective orders on behalf of victims. But oftentimes what we hear back is that there's this misunderstanding or misconception that when you apply for a protective order as a victim, that it's immediate and that you essentially walk out with a protective order. And that, of course, is not how it works, but is one thing to just be sure that we're reminding our victims exactly how the process works. So lastly, just when it comes to some services for victims and safety mechanisms, we have, as most district attorneys' offices have, we have a victims assistance program here at the Bexar County DA's office. We have the largest victims assistance program in the state of Texas, and which is significant. We have grown, that program has grown over the number of years. I'd say maybe about 4 or 5 years ago, we added, not only do we have victims advocates, but we added new positions called crime victim liaisons. And we'll talk a little bit more about them and their importance a little bit down the road. But what I wanted to point out here is that most district attorneys' offices, particularly ours, we do have professionals here that are helpful to our victims to assure that they're communicating with our victims on pending criminal cases. Sometimes we get victims that call that are actually, they don't have a criminal case, but they need help in some way, whether it's safety planning, whether it's housing, whether it's childcare, and we have people that can refer them to the appropriate services, whether, maybe they need to go to the battered women's shelter, maybe they need to walk across the street to the FJC, or seek counsel from a private attorney, but we can provide that information and point victims into the right direction. Our victims assistance personnel also provide court accompaniment, so they are kind of the navigators throughout the criminal justice process for our victims, and they of course can provide a plethora of information, whether that's on how to get a protective order, whether that's on the case updates, whether that is how to become notified by the VINE program when an offender has been released from jail, or even help with crime victims compensation through the AG's office. So we are staffed with those folks as well. So I'm going to jump into navigating the criminal case. So most of you are probably familiar with some of this, but essentially we do not create a case. The investigation has to start with law enforcement. I have, of course, San Antonio Police Department and the Sheriff's Office here. We have 50 something plus law enforcement agencies that we work with. These logos were just easier to put onto the PowerPoint. So law enforcement will, once notified that an offense has occurred, we will see law enforcement go to a scene and conduct an investigation. And the short version of that is that they're going to interview witnesses, they're going to collect evidence, they're going to write reports, they're going to start that investigation at the scene, and then most often there will be follow-up investigation depending on the type of case, where a detective is assigned or an investigator is assigned to the case to finish the investigation to make sure that all relevant evidence is obtained and then submitted over to the district attorney's office. Law enforcement does not have to file every case, of course, that they investigate, and many times they don't. And they have the option to file it with our office if they think probable cause exists. They have the option to what we would call PFI, that's the San Antonio Police Department lingo, but it means pending further investigation, which means that they don't have enough evidence at that time to file the case. Law enforcement standard, legal standard for filing a case is they will, if they find that they have enough information to show probable cause exists that an offense has occurred, they will file that case and send it over to our office. I did put here, I mentioned jail cases, bond cases, at-large cases. We have all sorts of cases. Jail cases are those cases where an offender has been arrested and continues to be in jail for whatever reason. They have not been able to make the bond, or for other reasons they remain in jail pending their case. We are under strict timelines. So once law enforcement submits a case to our office, we have just under 90 days to get that case to a grand jury if it's a felony, in order to timely proceed. We cannot take a case to a grand jury without all of the evidence. So sometimes that is a very time sensitive area. Bond cases, when an offender has been arrested and then is released on bond, subsequently, we have a little bit more time to get those cases reviewed and presented. And then at-large cases are non-arrest cases. Most other jurisdictions actually don't even have at-large cases. We do. We take at-large cases, which means that law enforcement has conducted an investigation, but there has not been an on-site arrest. They are submitting it to our office for review, and only unless it's filed on the misdemeanor level in courts or presented to a grand jury and indicted will an arrest occur. I'd say on average of 1 to 3 years, it takes us on our felony cases to get to trial. Our misdemeanors a little bit less time, but some of them are getting up there in age as well. A lot of that has to do with just sheer volume. My personal opinion, sheer volume, not enough courts, not enough staff. And then of course you throw in COVID, where for a period of time we were working remotely, but courts were not able to have jury trials, and that can prevent cases from moving when there's not jury trial lingering. So COVID has caused some of those delays too. When law enforcement submits a case to our office, this is a pretty thorough list of evidence. I used this slide when we were talking with law enforcement just to remind and help remind them that to send, it's just, evidence now we have found is just increasing voluminously in every way. In technology, we have so many more phones, we have so many more computers. There's just so much more evidence available to us now than say 10 years ago. So this is something that we will see them ask and hope for them to put these items together if they exist. Everything from reports to physical evidence, to scientific evidence, to statements, to body cam, 911 calls, and any kind of technological evidence. All of those items are items that we have to have before we can proceed on a case. So once law enforcement decides to file a case, it then comes over to the district attorney's office. We're in the middle of going paperless, so it's It's a little bit painful right now when we were trying to adjust to different changes that are happening. But in the end, the case comes over to our office and it is assigned to the Family Violence Division if it falls into these categories. And this is all of your child physical and sexual abuse, adult sexual assaults, felony family violence, misdemeanor family violence, and human trafficking. Right now, the division is about 101 people. That includes prosecutors and investigators, as well as victims assistance personnel. There was a short period of time where I wasn't here at the office, and where I had left sometime maybe around 2017. I've been here total of a little bit over 20 years, and in that whole period of time, we grew. We've grown significantly the past, I would say, 3 years. We've grown significantly. Some of that has been reallocation of resources, and some of that has been additional funding from the Commissioner's Court. So when a case comes to the office and is filed, whether it's an arrest case or an at-large case, the offense has been committed allegedly, and the investigation has been done by law enforcement. They send the case over to us, goes through a bit of a process. We are paperless, sort of. We also have files created where there are some evidence that we cannot use digitally. So some of that evidence is still in physical files. The files make their way, the cases make their way through an investigator, DA. This is a DA investigator. So this is a licensed peace officer who's tasked with providing and obtaining additional records. That might be CPS records, medical records, things like that, therapy records, school records, and then putting together the rest of the case. Once an investigator has worked on a case, it goes then to what we call a CVL. That is a crime victim liaison. And we'll talk a little bit more about their role, but essentially their role is to make early contact with victims on our misdemeanor and felony family violence cases. And that's been a huge change over the past few years as well. And we'll talk a little bit more about that. Once a CVL has made that initial contact to a victim to let them know we have a case, this is what we're looking, this is what we have. We'll check, the CVL or the advocate will check for whether or not we have a victim that is in need of any kind of resources, make those appropriate referrals, obtain additional information, and document all of that. Once this initial contact has been made, the case then goes to an intake prosecutor for review. That intake prosecutor can ultimately make the determination whether they want to present the case to a grand jury if it's a felony, or if they find that we do not have sufficient evidence to prove this case beyond a reasonable doubt, they have the authority to reject the case or dismiss it, however you want to word it, but to essentially close the case. That might be sent back to law enforcement for additional workup. That might be sent back to law enforcement asking for to locate additional evidence. That might be closing it just because we can't get there, at least right now. Once a case is indicted by a grand jury or filed in a county court, if it's a misdemeanor, then the case will start to it'll go onto a docket, a trial docket, depending on the court, county court, district court, and it will start to go through a rotation, if you will. Most of our felony courts right now have somewhere well over 1,000 cases, I think, over each court. So each of the 10 district courts has well over 1,000 cases, if I'm correct. I'm estimating. I'd say 25–30% of those are family violence type cases, child abuse cases. As the cases move through the dockets, this gives the prosecutor in the state and the defense the opportunity to confer, to share evidence, to negotiate plea agreements, to talk with witnesses, determine whether or not we can prove the case ultimately, or go to trial. I talked a little bit about investigators, but the investigators in our office, this is one of the first stops that our cases make. The investigators are responsible for making sure all of our criminal histories, our witness criminal histories, victim criminal histories, defendant criminal histories are all included in our file. They obtain outstanding evidence, which is usually evidence that law enforcement can't obtain. So for example, if we have a child that was severely injured and is in the hospital, for some time and law enforcement files a case with our office, they may not have the full medical record, and that would be something that we would request through a subpoena on our side, just because those records would not have been available at the time that law enforcement filed the case. Let's see. So these are our investigators. These guys were in a meeting when someone took this picture. I didn't tell them I was using it, so don't tell them. Trial support. So trial support, our investigators do that initial workup on our cases to help with the completion and make sure we have everything that we need. As the case progresses through trial or through the process and we get to trial, which is really only probably a fraction of cases that actually go through the trial process, our investigators are responsible for locating victims. Sometimes, especially in our domestic violence cases, that can be quite challenging. The longer a case is going through the process, again, it's an additional challenge that we face, and we'll talk about sort of why that happens. But they are also tasked with issuing subpoenas for witnesses that might need those, and also providing transportation for witnesses, as well as any kind of security for our teams. Crime victim liaisons, we mentioned earlier, so I would say maybe 2017 or so is when we actually started when we got these positions. The need for them, checking my time, was critical. Historically, what would happen, and I'll give the example on a misdemeanor case. Misdemeanor case, an arrest would happen, the case would be filed in the county courts, and it would go on a docket where there's hundreds of cases a week. And it was not until the case was on a docket and first or second setting, where our advocate assigned to the court would reach out and provide information to a victim. So you kind of, if you think about the timeline, in many cases, that was months after the actual offense. So that was a huge gap that we had, where the offense occurred, an arrest was made, but then it has to go through this process. By the time we were able to reach out to a victim utilizing our advocates in the courts, months had gone by. And as you know, most of you that are those of you that are working with victims, that's critical, because during that time frame, you have a victim that is going through a number of different things, and not having contact with our office is frankly detrimental to a victim. They don't know what's going on with the case. There's not somebody there to provide them resources or refer them to resources if needed. So these crime victim liaisons were implemented, and then we were able to get some additional positions in earlier this year, particularly on our misdemeanor family violence cases. But these crime victim liaison personnel are there to make that early contact on our misdemeanor cases. Now, I'm extremely excited about this, but we went from, in 2019, it was several months before we were able to actually get contact to a victim. We changed it, we adjusted it, and we narrowed it down to several weeks, maybe 4 or 5 weeks, to where we were making that contact post arrest. And now, as of earlier this year, we are making that contact the next day, unless it's a weekend. If it's a weekend, then that might be Monday or Tuesday. But the next day, for the most part, within 24, 48 hours, we're able to reach our victims on these cases, and that has been tremendous. Intake review process is once our CVLs are able to reach out to victims on cases, answer questions, refer them for services, and provide them with any information they may need, then an intake attorney will review these cases, whether it's a misdemeanor or whether it's a felony. Our prosecutors will be tasked with reviewing all of the evidence that has been submitted. They will have to request anything that might be missing from law enforcement. They might ask law enforcement to take additional action in different, depending on the case. It might be an additional statement from someone. It might be a phone dump or a computer, seizing a computer, or things like that. The prosecutor, once the evidence has been reviewed, Once a CVO has made contact with a victim or guardian, then the prosecutor will be tasked with determining what offense is the most appropriate offense to charge. They'll evaluate that case to make sure we can prove it. We might get cases where we know or we feel or we believe that a crime has occurred, but we may not have sufficient evidence to take us to that beyond a reasonable doubt threshold. And so when our intake attorneys are reviewing these cases, they are reviewing them for evidence sufficiency and provability. The intake attorney has the option to present the case to a grand jury if it's a felony, or reject it. On a misdemeanor, they have the option to file the case through the appropriate charging documents or reject that as well. The grand jury process this kind of makes it look more complicated than it really is. But essentially, if I'm presenting a case to a grand jury, I have the option, I have two options. I can reject a case, and I have different reasons that I might reject a case. If it's further investigation, I might ask law enforcement to do additional work and refile that case. If it's just not enough evidence and we can't make it, then we might just close that case. When we present a case to a grand jury has the option to true bill the case, which means they find that sufficient evidence exists to send this offender through the criminal justice process. They can pass on a case if they're not certain or they want additional information. They can indicate that it's called a pass, and they can send the prosecutor on their way to obtain additional evidence or look into further matters. They can also no bill a case. Once a case is in no bill, is essentially works as it's effectively a dismissal. It means a grand jury found that there was not sufficient evidence to proceed. So once a case is indicted, then you can see it goes down onto a trial docket, and then it goes through the process of a plea, a dismissal, or a trial, and then some of those other outcomes. Okay. So once a case, let's say with a felony, is indicted, it then is going to end up on a docket in a felony court. If it's a misdemeanor, it will end up in one of our misdemeanor courts. In both the felony courts and the misdemeanor courts, we staff each of those courts with 2 or 3, depending on the court, 2 or 3 family violence prosecutors. An advocate and an investigator are assigned to each of the trial teams. That's both for misdemeanor and felony. These teams work together to navigate through the docket. So every week they might have a trial docket. They will have a number of other pre-hearing type dockets. They will have different motions. They will have sentencings. They will essentially handle all of the case, every stage of the case, from indictment through the resolution process. That would be the trial team that does that. So as these cases are on a docket, and there's I found that a lot of times some of our victims are surprised to hear when we explain that there's, say for example, the victim has a case and their court date is on December 1st. But when I show them a docket, or I explain that on the docket there's 100 other cases, that is something that I have found that a lot of our victims are surprised to hear. And so there's this misconception that when they get a notice or they're told that their trial date is on December 1st, that means that case is going to be heard on December 1st. And that's not actually how it works, but it's going to be one case of many on a docket, and it will be up to the judge and judge's discretion in choosing which case to push and to hear first. So as these cases contain other cases that don't get heard, get reset for another court date, 1 month, 2 months, 3 months down the road. And then the process just repeats. So our prosecutors are tasked with evaluating these cases during that process. They're meeting with witnesses, they're providing discovery to the defense, they are filing motion, addressing motions, and evaluating the case to ultimately determine what they believe to be the best resolution for a victim or an offender or the family. Pretrial preparation is something that happens during this process. As a prosecutor is evaluating a case, one of the things that they're doing is preparing the case for trial in the future. That will include meeting with everybody associated with a case. That will include assuring that we have all of the evidence that we need, or developing more if that is the case, but essentially getting the trial and the witnesses ready for what will ultimately be a trial if the case is not resolved through some other resolution. Other resolutions that are available besides trial are plea agreement, which is probably the majority of our cases resolve. You'll also hear that as referred to as a plea bargain. It's just the words that we use in the local community. I wish that we continue to use plea agreement, because that plea bargain sometimes just gives this connotation that we're not doing all that we can. Plea agreement, when we're reaching plea agreements, we have to consider, of course, the strength of the case, of course, any trauma, any kind of stress or pressure that a victim will feel or have to go through. Whether or not we have a victim is actually something that is going to be considered and when we reach a plea agreement as well. So throughout, as these cases are set on dockets and throughout that process, working with the trial team are advocates. So these are our victims assistance personnel that I mentioned earlier. Our advocates are overworked and underappreciated, but they are essentially the glue that holds together these trial teams, because your advocate is the person that is the liaison between our victims on our cases and the prosecutor. For example, you have a prosecutor that's in court and taking the action that they may need to be taking on a case, but the advocate is the one that has that ongoing regular communication, at least until the case is becoming ripe for trial, or during that trial preparation stage where if I'm prepping a case for trial, I will have, of course, the witnesses come in and meet with me, and we'll talk about the whole process. We'll talk about the process, we'll talk about the case, and really spend some time with them in those areas. But all the other communications about court dates and services and referrals, that's going to be the role of our advocates. They wear a lot of hats. They're very good at what they do, and we're lucky to have those folks. So when I was kind of thinking about this presentation and what I wanted to share about the criminal justice system, this was something that kept kind of coming back to me, and I think the struggles have changed significantly post-COVID, the struggles that we have in our family violence cases, whether that's a child abuse case or a domestic violence case, but primarily our domestic violence cases. Most of you are familiar with, you've had trainings on, you've worked with victims, you've worked with offenders, you're familiar with the family violence dynamics. But those family violence dynamics have a tremendous effect on our victims, and what that effect, depending on how they've affected our victims or survivors, that's going to play a significant role in how our victims are going to choose to proceed through this process. We'll talk a little bit more about that. COVID, I don't think that's anything new to anybody, but COVID, of course, because of lockdown and that shutdown in jury trials has caused some delays, and that's going to lead to backlogs that will take some time to get through. But at least it feels like we're trying a lot of cases, and we're getting cases heard and obtaining justice as best we can. But it's going to take some time to move through those cases where we were kind of halted because of the COVID shutdown. And then the third major challenge I think that we see, and this has been a significant change as well, are the expectations that we see from the public, but also from our jurors. It feels, I don't have any statistics to support this, but it feels that what used to be a more straightforward case pre-COVID, I can put that same case before a jury now, and a jury will have far more questions, far more concerns, different expectations than they had before. I don't know exactly why that is. I can make some guesses, but what we are seeing is that there are some demanding expectations that the public has, that jurors have of law enforcement and of victims. And then, of course, just those that don't have a whole lot of experience with family violence, which is great, but those that don't have a lot of experience with family violence, or relatives or friends or family that have been through family violence situations, tend to not always understand it. I'm not going to go over this. I just wanted to put it out there to remind you, because this leads to one of our more significant challenges. But you're familiar with the cycle of abuse that we see in family violence cases or domestic violence cases, that honeymoon period, that tension period, walking on eggshells period. Usually that tension building leading to the explosion is because we have an offender that has felt a loss of control over our victim, over a situation. And so then we usually see an explosion. There are some of you, most of you have seen the power and control wheel, and how there are different types of mechanisms and ways to utilize power and control to assert control over victims. But all of these dynamics are critical in understanding some of the difficulties in the criminal justice process, or from at least a prosecutorial perspective. When we have, in many of our cases, and some of that I think probably has to do with the fact that it takes so long for a case to move through the criminal justice system, but some of it I think is also because of these family violence dynamics. We see so many cases where, because of these dynamics, we have a victim or a victim survivor who is not able to proceed through the criminal justice process. They're not able to safely go through the process where they have to come and testify and talk about what happened. Many of them are going to stay in these relationships for some time. As you know, it takes many times in attempts to leave a violent relationship. So we don't always, just because an assault occurs and a crime occurs, doesn't always mean that that's when our victim survivor is going to leave the abuse. In fact, many of them will continue on operating as a family with children. But this is what we see many times. We see and we hear, these are real statements, but we hear this coming from our victim survivors. A lot of it, if you look at it, really appears to be a lot of self-blame. And we constantly are trying to assure that our victims are going for counseling and getting counseling if we can reach them. But this is what we often see in the majority of our cases. We're going to be in a situation where we don't have, I'd say more likely than not, we're going to have a victim survivor who is not able or not willing to proceed through the process. And that creates some issues for legal issues. We have some legal limitations when that happens. We know why this happens, right? And this is why, when I said earlier that those of you who are working in your community-based service providers and advocates, when you are helping and assisting our victim survivors on the front end of the case, then we can reduce some of these effects. We all know that domestic violence is a traumatic experience. We know that, and we know that it can change the function of someone's brain and how they operate, how they make decisions, how they handle different situations. And so we have, in order to have victim survivors that are able and willing to either move on or move forward or move through the criminal justice process, if we don't have those of you that are providing resources and services to victims, if we don't have you doing that on the front end, then that's going to create a situation where I go back to the other slide, but I clearly can't operate this well. That's where we have a situation where our victims are not equipped or able to safely go through the testifying process. So those of you that are working with victims in this component, on those early stages, thank you. It does make a difference. It will help. When we don't have a victim that is able to testify or willing to come and testify, we have to evaluate the case from a different perspective. The short of it is, I'm running a little bit low on time, so I'm going to move through some of this a little bit quickly. But the short of it is, we now, as a prosecutor, I have to do a different analysis if I don't have a victim. Typically, if I do have a victim, I'm going to bring this person and walk them through everything that has happened. That's going to usually meet most of the elements of the offense that I have to prove. But if I don't have a victim, then I have to start thinking about what evidence I have to meet all of the elements that I need to prove. That when this happened, what exactly happened, the injuries that were sustained. I have to figure out how do I have admissible evidence? And then how am I going to get that in through the court process? Because again, this is another thing that I found is a common misconception with victims, is this the understanding that I wish I could just give Judge Gonzalez all of our police reports and all of the body cam and all of the recording phone calls and stuff like that, evidence on our case, and just give it to the judge or a jury to make a determination. But obviously I can't do that. And so we have to jump through some hoops. When we do not have a victim, we have to make sure that the evidence that we do have to support our charge, that it is admissible under some hearsay exception, and that it is also we do what's called a Crawford analysis, and I won't get into all the details of that, but a Crawford analysis, which would allow us to admit certain pieces of evidence. You have to be mindful that every person charged with a crime, every offender, every person charged with a crime has the right to confront their accuser. And so that becomes something that it seems like just yesterday it changed, but it's been a long while. Before pre-Crawford, not before Crawford, we were able to do so much more. Now we have Crawford. We understand why. We completely accept that is something that we have to work through. But it can make those cases where we don't have a victim, it can make those cases impossible to proceed on. So we do an analysis there. We have proceeded on cases where there is not a testifying victim survivor. We have been successful on some of those cases, but many times we're limited and unable to do so. COVID, we talked a little bit about those backlogs and what that means for our dockets. And so the COVID is challenging when you put that with the expectations of jurors and the public. So what we then have is we have COVID that has created delays in many of our in getting resolution in many of our cases. And then you add into that these expectations that we see now, more so than we did, I think, before. It just becomes an uphill battle in being successful in some of these cases. We've been very successful on some, particularly recently, both misdemeanor and felony offenses, but it's certainly not met with its challenges. And some of that is the lack of understanding on the public's part, and in terms of understanding family violence dynamics and how they work, as well as high expectations of law enforcement, high expectations on the criminal justice system, and the unfair expectations on victims. Many times we have victims that are going through those traumatic experiences. And so how they recite the facts of what happened, how they articulate what happened, how their emotional demeanor might portray, can be something that jurors and the public, person in the public that's not familiar with family violence, that can cause issues for them in understanding why these things happen. And I'm going to go, I know I'm almost over time, so we got a late start. I'm just going to try to get through this. Criminal case resolutions. So as those cases move through the criminal justice system, and ultimately they will either resolve by a dismissal, they will resolve by incarceration, they will resolve by probation or deferred adjudication. These are a number of programs that we have. Anytime somebody is placed on probation or on deferred adjudication, it's a prosecutor can make recommendations, a judge can make final decisions on what types of services we can help put an offender, obligate an offender to doing, with the hopes that we're addressing those underlying issues, and with the hope that we can address those underlying issues, that we can reduce the likelihood of recidivism and future violence. So these are just some of those programs. Let me go back this one. When a person is placed on probation and subject to all of these conditions for years at a time, there oftentimes will be a violation, and a violation works very similar to those violations on bond conditions. So it will be a motion that we can file with the court to revoke that probation and sentence the offender. It might be, depending on the severity, it might just be a sanction, or it might be amending the conditions of probation to include additional resources and services that might help an offender no longer offend. Pretrial diversion is newer. There are multiple kinds of pretrial diversion. Pretrial diversion is a way for an offender to be subject to conditions and services, but ultimately at the end and upon successful completion, there's not a conviction. This is something that we have at least three different kinds. There's a standard PTD, pretrial diversion. We have Reflejo, which is a specialty court out of County Court 13, which is a focus on substance abuse and domestic violence. We also have a mental health PTD program out of County Court 12, where the focus there is on mental health care, and then of course with the domestic violence. Pretrial diversion sometimes is an option that we might utilize when we perhaps maybe we don't have a victim on a case that's available or willing to come, and maybe we're not going to be able to prove this case without that person. This might, and maybe it's a first-time offender, or it's not a weapon or severe injury. Pretrial diversion might be the way that we're able to get an offender into a BIT program, with getting some drug and alcohol treatment or mental health care. This might be the way to do that in lieu of just closing the case. So this is something that we work on. We spend a lot of time reviewing cases for pretrial diversion as well. And of course, there's a number of factors, just like we would decide when to send someone to, or recommend that someone be incarcerated, that those factors are going to be the same factors. All of these factors that you're looking at here are going to be considerations that we make when we determine, is incarceration the answer? And sometimes it's the only way to keep a victim in a community safe. But then there are other times where maybe we need to consider probation and try to get these resources and services out to address those underlying issues. So all of these are factors that we would consider in those circumstances. So in short, when there is an adjudication on a family violence case and a court makes that affirmative finding of family violence, there are some firearm prohibition consequences. You can see them here. Under Texas law, it's a 5-year prohibition. Under federal law, it's lifetime. I did put this study because I thought it was important, but why does it matter for families? Presence of a firearm in a domestic violence situation significantly increases the risk of homicide. I had another beautiful slide, but I was worried about me, so you won't see that one yet. All right, and then I did include some information on parole. If an offender is sentenced to prison, there's still, through the parole, the Board of Pardon and Parole, there's actually victim services, the victim service division that works through the board. And so that information is here because we will also provide that information to a victim. Say we have a trial and the offender is sentenced to a significant period of time. We'll provide this information so that they can be part of that parole process as the time comes, because a victim is entitled to submit that protest letter, request an appearance, request special conditions, and they can still be involved all the way through the end of that process, many years down the road. And this is the information for that division. So that's what I have for you today. I just wanted to say thank you. I apologize, we ran a little bit over. I have included my information here at the end because I know we're out of time. If anybody has any questions, concerns, complaints, case issues, whatever it may be, I'm happy to respond, take the time with you to figure out what needs to happen. Here's my email and my personal cell phone number if anybody needs any help at all from our division. Thank you.
Thank you so much, Meli. That was really wonderful. We appreciate it. Thanks everyone for joining. We have about a 10-minute break before the next session. So check your program, and I chatted in the CLE link for those of you who are desiring CLE credits. Thank you again so much, Meli. Take care, everyone. Bye.